Good morning. My name is Taino Palermo. Some of us met yesterday. Some of us are here today for the first time. And so this is the last bit of talking you'll hear from me, thankfully. We have a great 2 days of panelists, and yesterday we kind of kicked off the business aspect of what we do at the federal courthouse. We heard from the chief judge, which was great. And we kind of laid the foundation about who we are, what we've been doing over the last year and a half, and where we hope to go over the next couple of years. So thank you again to everyone who has been involved in our growth and development and supportive along the way. And so I want to kick off today, get us started. This first panel is I'm really excited about. I mean, I'm excited about them all, but as I was doing my roadshow to kind of meet the practitioners in this area geographically and professionally, one of the first folks I connected with was Nicole Friederichs at Suffolk Law, who was connected to us by, we were connected by Dr. Diamond, who we heard from yesterday. And so it's by no coincidence, his name is a reoccurring theme that comes up because a lot of these connections had flown through him. So it was really great to meet Nicole and learn about the work they were doing at Suffolk. And she was able to breathe a little sigh of relief because she has to turn people away often because of how vast the need is. And they do great work. And so it's, you know, it's hard to find people who do good work when the need is so fast. So, and our other panelist, Andy Reed, who you'll meet, is a weird connection in a great way. He is co-counsel to Onondaga Nation, who is actively litigating in the Inter-American Court. And so I was in Syracuse, lived in Syracuse for a long time before moving to Rhode Island. So I know the Onondaga Nation and their history, and especially the environmental catastrophe that is and was the Onondaga Lake. And so us coming together today is a really exciting panel, and I'm excited to moderate it. So without further ado, please welcome Nicole Friederichs and Andrew Reed. Okay, so just to give everyone a little, let me hold this, a little grounding in how we're going to run through these panels is everybody. So as I said yesterday, you know, we are here to create and establish a platform to elevate these best practices and these practitioners doing this work on the East Coast and throughout U.S. territories. So so what we're going to do is give our presenters time to present on their work, kind of, you know, be thought partners in the process, share challenges, and then we'll field some questions and see how the conversation goes. And so we'll start with Nicole. We have her presentation queued up. And so just let us know when you need to go through slides, but however you want to set us up, stage is yours.
Can I leave it like this? Is that okay? Is that okay? Good. I know for folks online too. Thank you, Taino, and thank you to the Center for having me today. I'm really excited to be here. It's always a pleasure to share with others some of the work that we're doing at the clinic and talk about Indigenous rights. At the clinic at Suffolk Law School, we've been around about 12 years. We do both international human rights work, which I'll focus on today, but we also do nation building work, working with a lot of several of the tribes currently in the New England region. We work with tribal courts, with tribal councils, different departments within tribal governments on drafting laws and policies and procedures, drafting court rules. So there's a range of work that the students and I do with tribal nations here in the United States. But today I'll be focusing primarily on our case out of Guatemala. So if you want to start to the first slide, I thought I'd just start a little bit for those of you who might be a little bit unfamiliar with international human rights law and kind of why we engage with those forums. I just wanted to list kind of some of the reasons why you might want to consider as an advocate. You don't have to be a lawyer to go to these international human rights forums. It does sometimes help, but you don't have to be legally trained. But there are reasons why you might want to consider using the United Nations, or in this hemisphere, the Inter-American Human Rights System. One reason might be that you've exhausted remedies here domestically. So if the next slide there and just the first point down. So you've gone through different court systems here in the United States, and you realize you're losing in US courts, which is often the case, unfortunately, here when it comes to Indigenous rights. You might want to pursue something internationally. You might want to complement your human rights work that you're doing domestically, internationally. So you might have a pending case here, or you're doing advocacy domestically, whether it's in a courtroom or lobbying. You can go to international human rights systems to complement that work, right? Get another voice in there to talk about the rights that you're trying to focus on domestically, but getting that international kind of perspective. Sometimes a remedy isn't available to you domestically. I think of the Agostini case, for example, of Nicaragua about 2 decades ago. They were faced with a situation where the government of Nicaragua wasn't recognizing their property rights. They didn't have a piece of paper that said, this is our land. They didn't have a deed. And so back in the late 90s, they pursued advocacy at the Inter-American Human Rights System, starting with the commission first and then to the court. And in a seminal court decision in 2001, the Inter-American Court said, yes, Agostini, your property rights are recognized under international human rights law. And so therefore you have a situation where an outside court is establishing this legal right that isn't being recognized domestically. You can go back to Nicaragua and say, you have this judgment now that you have to now implement. And then finally, this is one of the things I love about international human rights law, is that you can use this kind of separate body of international human rights law. And it's really robust when it comes to Indigenous rights. You have the UN Declaration on the Rights of Indigenous Peoples. You now have the American Declaration on the Rights of Indigenous Peoples. You have ILO Convention 169. You have the expert mechanism on the rights of Indigenous peoples. You have the UN Permanent Forum on Indigenous issues. I mean, there's a whole range of forums there for Indigenous peoples to kind of go to, and a body of law on which to rely. And so what's really great is that you can use that body of law to kind of evaluate domestic law here. And the example that I think of is from the Navajo Nation in the San Francisco Peaks case, which is still ongoing, where you had about a decade ago, the UN Special Rapporteur, that was Jim Anaya at the time, coming in as rapporteur and telling the United States, look, you might think that you're protecting religious freedom rights for the Navajo Nation, but when it comes to international human rights law, you're not meeting those obligations, because domestic law might recognize those rights in one way, but international human rights law recognizes those rights more robustly. And so we as advocates can use that body of law to say, look, here's really how you have to be looking at this right to religion or spirituality or property rights, whatever it might be. And as governments here in the United States or around the world, governments should really be striving to kind of evaluate and ensure that its domestic protections for Indigenous rights or whomever are really meeting those international human rights standards. So that's a quick rundown of kind of why we go to international rights forums for our work. The next slide, it just lists 2 cases. I'll be talking about our Guatemala case, but just to point out, if you're interested in hearing, I have worked on the Western Shoshone case. I was lucky enough to work with Carrie Dan back in 2008 while I was at Arizona doing my LLM. And they have the first, and I'm sure Onondaga Nation's probably looking to this, and I think you had mentioned, Andy, this is the kind of first case since the Western Shoshone case and the Dan case in 2002, where the Inter-American Commission might be looking at the property rights of a particular tribal nation here in the United States. But I worked with Carrie Dan and the Western Shoshone Defense Fund back in 2008 when they were doing that work at the UN Committee on the Elimination of Racial Discrimination. And I also worked on the Belize case. It also had pursued advocacy at the Inter-American Commission back in 2004, received a report from the commission. They were able to use that report, go back into Belize. This is the Maya people in the Toledo district of Southern Belize, and go back in domestic court, get more judgments, and they're in the process of implementing those property rights as well. So happy to talk about those as well. All right, so let me talk about Guatemala. I think the first thing probably to do here is to show that video, if that's easy to do, because I think it's a really great video that Cultural Survival put out. They're an NGO that have been involved in this issue for almost 2 decades. And this video can do a much better job. It's actually probably more interesting to look at than to me. And just hear about kind of what community radio means for Indigenous peoples in Guatemala, as well as around the world. I'll point out that 50% of the population in Guatemala is Indigenous. And radio, especially for those communities that are rurally based, really important for them to be able to use radio as a way to communicate, to share information, to tell their stories, to speak in their own languages, to share their music culturally. So important. And so it really kind of spells it out. I'm hoping I just ended the perfect timing there. We did.
Es un medio donde podemos expresarnos las mujeres. Es un medio donde se da a conocer nuestro idioma materno, nuestros valores culturales, nuestra identidad, y también aprendemos sobre nuestros derechos.
A través del Ministerio Público son allanadas las radios, son encarcelados los comunicadores, son decomisados los equipos también. Es una situación con la que nos estamos enfrentando todos los días.
Pues la verdad es que sí me siento asustada porque el allanamiento que fue hace 2 años, creo, me da miedo ver a los ministerios públicos, a la policía, porque sabemos muy bien de que ellos nos persiguen.
Nosotros no queríamos exigir al equipo, porque teníamos miedo. No queremos parar en la cárcel mientras que nosotros estamos trabajando, no estamos haciendo algo malo, pero aún así uno le da miedo enfrentar esas situaciones con los grandes empresarios que están en contra de las radios comunitarias.
También con métodos natural, por eso tengo que mencionar la importancia y el valor madronas para las comunidades, ya que la red normal y la red como que medicina o escumbal para que como dijo
se siente la presión, la dominación de las empresas de las radios, que ellos han acaparado las frecuencias. Las leyes no están para nuestro pueblo. Las leyes solo están para unas cuantas minorías.
La iniciativa de ley 4087 pretende que el Estado permita una frecuencia por municipio. Eso es lo que estamos pidiendo a través de esta ley.
Es lamentable cuando el pueblo clama sus derechos, pedirle un medio de comunicación propia, donde podemos educar, donde podemos transmitir mensajes, donde podemos promover nuestra cultura, nuestro idioma, nuestra espiritualidad, o sea, todo lo que es del pueblo maya. O sea, ahora una vez más se nos quita la expresión como mujeres, como jóvenes, como ciudadanos de este lugar. Para nosotros es lamentable, pero va a continuar. Eso va a continuar nuestra lucha, va a continuar nuestra resistencia, como hemos venido resistiendo más de 500 años. Ser una mujer indígena es un orgullo. O sea, que cómo podemos unificar todo lo que nos rodea. Y gracias a nuestros ancestros que nos dejaron legado esa vida, esa identidad como indígena, como mujeres, como maya, vamos a seguir exigiendo pues nuestros derechos y ejercer nuestros derechos como personas.
Thank you. So yeah, I think that does a really great job of kind of explaining the context actually before the judgment. So this was created before the judgment was handed down by the court in 2021. So some of it is kind of in that context, but it does lay out kind of the situation. So there was, and still is on the books, a telecommunications law in Guatemala, which essentially regulates how radio frequencies are licensed. And it's a bidding process, right? So the highest bid wins. So you can imagine for Indigenous communities, participating in a bidding process that's based on who has the most money makes it really difficult to get a license. Essentially, it makes it impossible. I think there's only one instance where one community was able to get a license in Guatemala, and that was essentially mortgaging a house to get enough money. But for the vast majority, they haven't been able to. So they went through domestically, tried to fix this, right? They've been lobbying since the peace accords in 1995 to change this law. Actually, after the Civil War in the 90s, Guatemala promised that it would make sure that Indigenous communities had access to radio, because it is so important. You saw a clip there of a woman talking about kind of health programs, right? That or information that could be really useful for community members. And that hasn't happened. They've been lobbying. You heard them reference a bill that they've been trying to get passed in Congress to ensure that domestic law in Guatemala recognized community radio as a form of radio, and it made it easier for people to access the radio frequency spectrum so they could have a legal license and not get raided by the government, which happened a fair amount up until the judgment a couple of years ago. You'd have police getting a warrant from a court. They'd go in, they'd raid the station because they thought they were illegal. They'd occasionally arrest folks, they would seize the equipment, and then everyone's scared, right? No one wants to do anything after that. They really silenced them significantly in terms of those kind of actions by the government. They go to the Constitutional Court in Guatemala in 2012, 2011. They get a judgment from the Constitutional Court in Guatemala saying, well, you know what? We can kind of, see your point, but we don't find this unconstitutional. There's no discrimination here. The letter of the law under this particular Telecommunications Act is not discriminatory, even though de facto it is. And so that was it. So then in 2012, Cultural Survival, which was kind of part of the leadership of this movement in Guatemala, they have staff in Guatemala, reached out to us at the clinic. We had just started and said, would you file a petition at the Inter-American Commission of Human Rights for ours? And I had to think, well, okay, can I do this? Yes, I've been involved in some of this work before. This is a new area of law. I'm not a fluent Spanish speaker. Can we really take this on? So after some reflection, finding a lawyer that was a fluent Spanish speaker and English speaker, we decided to move forward. And that was in 2012. For those lawyers in the audience, let me just run some of the procedural history just to kind of show you how long this work takes. So we filed the petition in 2012. We also filed a request for precautionary measures in 2015, which wasn't adopted. Essentially, that's an injunction There were so many raids happening at this point that we felt like the commission should really step in and say, look, you need to tell Guatemala to stop raiding during the pendency of this case. For whatever reason, that didn't happen. My sense is at this point, I think they still are pretty overworked. The commission, they have, very few staff. It takes a long time to get things done, and this just didn't get adopted by them. The commission admitted the petition in 2018, so 6 years it took for them to actually admit it. That's pretty standard these days. It takes a long time to get things done just because so many individuals and organizations and communities are pursuing work and advocacy at the commission. And then finally in April of 2020, just as the pandemic was starting, they released their merits report, which found and agreed with all the violations that we had argued for. And I'll go over those in a moment. They made the decision, which is possible with Guatemala. It's not possible with the United States, but because Guatemala has signed on to the American Convention on Human Rights, there was now the possibility that they could go to the Inter-American Court and actually get a judgment as opposed to a report from the commission. So they make the step to refer this case to the court, and which we were very much on board with, because having a judgment is powerful, right, from a court. So we were supportive of that. The court moved quickly. I was really surprised. Even during the pandemic, everything was remote, but about a year later, we had a hearing remote. Unfortunately, we weren't able to go down to Costa Rica to go do that hearing in person, but virtually in 2021, in June, we had a hearing. I'll go over that in a moment as well. We had witnesses, 3 community witnesses. You'll see pictures of them in a moment. We also were able to get the UN Special Rapporteur on Indigenous issues to be an expert witness, Francisco Calitzai, who's also Guatemalan. And then 6 months later, we had a judgment from the court, a 100-page judgment. All 5 out of the 7 judges actually wrote concurrences, which was really impressive, and a really strong judgment, which I'll go over as well. So it's been almost 2 years. None of the reparations have been implemented, which again isn't a big surprise. States really don't want to have to do these things. So we're working hard in Boston at the clinic, as well as with our partners in Guatemala to get this implemented. Feel free to jump in with questions too. I know I'm moving fast here, but I'm happy to be interrupted as well. Here are 2 of our community witnesses, Maria and Rosendo. They were speaking from Guatemala and being questioned by one of my colleagues, Amy Chavarro, who's another lead attorney on the case. And basically, this is an opportunity for the judges who were also listening in to hear about the experience that they were having in their own communities around Indigenous radio. So my colleague Amy would ask them questions about, how do you use community radio? Why is it important in community? Give us some examples. Maria talked a lot about women, Indigenous women, the importance of, you saw a lot of women in that video being part of this community radio effort. And so they both testified along with Francisco Tsai and Khalid-Tsai, and this was an opportunity for us to share and educate with the judges kind of the importance, not so much the legal aspects, but more kind of why this is so important for communities, right? To have and to be able to access, and also to talk with the question that Amy asked at the end of each of their testimonies, are you scared? And each of them answered yes. I mean, they're living in these communities with the threat of raids. And yeah, there's a long history of violence there against Indigenous peoples too. So that kind of piggybacks on that. The next slide kind of overviews some of the violations, the human rights violations themselves. So the primary right that we were alleging was violated was the right to freedom of expression, right? Because Guatemala Indigenous communities could not access the radio frequency spectrum, a form of media that everybody else in the country could, they're being discriminated against. They have this right to express themselves, to share their thoughts, their opinions. There's a right of people in their communities to hear those opinions, to hear those thoughts, and that was being violated because they could not use this radio spectrum for sharing that voice. It also limits pluralism, right? If you think about a country that's 50% Indigenous and half that population's voice is not being heard, not just within their communities, but across the country, that limits pluralism, like only one voice is being heard. So we emphasize that too. The right to culture was another right that we also included too, clearly an important right for Indigenous communities, not just talking about culture, but here we're talking about land rights and property and language and history and the whole range of things. So if you click one more, or two more, that'd be great. Thank you. Talked about how, again, Guatemala violating this right along with the freedom of expression right with limiting access to the radio frequency spectrum. Radio is such an important way for communities around the world to transmit their cultures, right? If you think about transmitting to future generations, songs, language, history, stories, whatever it might be, you know, radio, if you're not having that access to radio, that can really limit it. And then the right to media, which I was most excited about. So the right to media is not found in the American Convention on Human Rights. It's actually found in the UN Declaration on the Rights of Indigenous Peoples, Article 16. And it comes from this idea that Indigenous peoples, because of this history of exclusion and oppression, states really need to take a more active role to ensure that Indigenous peoples have access to all forms of media, to really counter that history of exclusion and to ensure that their voices are being heard, right? So we really included this, even though it's not part of the treaties for the Inter-American system, but is connected to the UN Declaration, that we really want to make sure that the court understood that. Yeah. Sure, please. Yep. Yeah. Right. Right. Right.
So real quick, just
Yeah,
for the
yeah,
Zoom
please.
world, so they could hear the question. The question was, what's the difference between the report and the judgment?
Yep.
And then even with either or, what is the incentive for people to pursue this forum if the nation state won't abide by the ruling?
Right. Yeah, I mean, that's a common concern or frustration or criticism for a stronger word of pursuing international human rights options. I mean, to take an unfortunate example, the Western Shoshone, right? They had lost domestically. They got this great report from the commission in 2002. They got a decision from CERD in 2006. And still, right, the Dan sisters, both of whom have now since passed, you know, those rights are still not being recognized by the U.S. government, despite all this great activity and effort internationally. So sometimes it doesn't work, right? But there are situations where it does. And what I try to tell my students and, you know, communities with whom we're working, I have seen change happen. Maybe it's not big change that happens all at once, but it can happen incrementally. The judgment versus the report can be significant. I'll use Belize as an example. They weren't able to go to the court either because Belize has not subjected itself to the jurisdiction of the court. But it took that judgment, it went back into domestic courts in Belize and got a positive judgment from the courts in Belize. And they're still working on protecting their property rights in Belize, but it definitely had an impact on making that conversation move forward. And the court, the Belizean court, actually looking to the Inter-American Commission's report and pulling from it to say, okay, actually we see here, right, there's some rights here that we should be protecting. So in that context, even though it wasn't a judgment, you have a domestic court relying on the commission's report. And that's, if you're in that situation, that's what you're going to try to do, is try to pull in that language the best you can. Sometimes it works, sometimes it doesn't. With the judgment, it's different. It should be different, right? Guatemala has a list of reparations. I'm trying to see if that's my next slide. It might be, if you just want to pull that up. Yes, it is. So in our case with Guatemala, we have this judgment. The court lists these reparations. And we're still working on implementing them. It's going to take time, but I think eventually we will get there. I think states typically react maybe a little bit differently to a judgment as opposed to a report, because when they sign on that treaty saying we accept the jurisdiction of the court, you hope that that state understands what that means and will, you know, actually implement the decision. It can take years, sometimes decades, for states to implement them. I haven't done a study, I'm sure somebody has, to see kind of what the success rate is, but just kind of anecdotally, I think it does. Well, yeah, so the Inter-American Court doesn't have a police force, right? It can't go in and say you have to do these things. It can't seize government property or anything like that. So no, there's no push behind it. But, legally speaking, when a state, like any of us, when we sign a contract, when a state signs a treaty, it's telling the world, I am obligating myself to implement these rights. So there's a legal obligation there. Whether you can kind of enforce it in different means, no, not in this situation. So what we do as practitioners is we educate the government, we educate partners outside Guatemala, inside Guatemala. We sit down with the US Embassy in Guatemala, we sit down with the Norwegian Embassy in New York, and we try to continue to put pressure on Guatemala to uphold its obligations internationally. Does that answer your question? Maybe it's not a satisfying answer, but Yep. 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 Yeah. And right. Yeah. And that's the funny thing about, yeah, I mean, that would be useful. But I think part of the balance that, especially when you think about early on human rights, early on human rights movement after the World War II, diplomats, countries had to play a little bit of a balancing game. They wanted these states to sign on to these treaties, right? These human rights treaties, especially after World War II and what happened there. But at the same time, they also had to respect their sovereignty, right? So they couldn't push too much to say, okay, sign on these treaties, but we're also going to be able to do sanctions, for example. They probably wouldn't have gotten a lot of people to sign on to those treaties. So it's always a little bit of a balancing game. I think the sanction piece maybe doesn't come directly from the court, but it might come, say, for example, if Norway is a funder of Guatemala, if we can educate the government of Norway to say, look, there's these problems here. They're still not doing what they're supposed to be doing. It could be that Norway through back channels says, you know what, you need to do this, or we're not going to, send that whatever aid over or something like that. So that's where it can be used. But you're right. It's not a perfect system. But we hoped that we've just yesterday, a couple of days ago, we got some news that Guatemala is closer to implementing one of its reparations. So we're getting there, but it'll take time. Again, I know, and that's not so satisfying, but just to offer an explanation. So in terms of the reparations that Guatemala, the court ordered, one is to, you have to reform your law. You have to change the law in Guatemala to make sure it's not discriminating against Indigenous peoples. That they said there was no time frame from that. It's basically a reasonable period of time. It's going to take a few years. Essentially, if you're talking about a national law that has to be amended or totally revamped, that's going to take some time. You have to stop the raids immediately. Since the judgment, we have not known of any raids, so that's a change. You have to overturn any convictions. There's progress being made on that. We're not quite there yet, but the government is getting closer to addressing that. You have to publish the decision in lots of different forums. So on Thursday, we got word from the government of Guatemala that they finally, after almost 2 years, you think it'd be pretty easy to publish a judgment that's already been written. They translate it into 4 Indigenous language, and it's published in their official government paper. And then there's some reparations that are specific to the communities. How much time do I have? What should I wrap up here? Okay. And all of this has to be done in consultation with Indigenous communities. I assume everyone in the room probably appreciates how important consultation is, right? And internationally, there's really robust jurisprudence on the duty to consult by governments with Indigenous peoples, and the court made that clear too. If you're going to be adopting laws, if you're going to be adopting new regulations around the radio frequency spectrum, you must be consulting with Indigenous peoples. What I have found surprising when I go into these meetings with the government or even with communities is that no one really likes to talk about consultation. The government doesn't want to, and even sometimes communities don't want to either, because they've had really bad experiences with it. So for us here, as a group of lawyers who see this judgment, understand the law, or try to bring this up regularly to ensure that consultation does happen. This slide, I won't go over too much, just in the thinking about time. This is basically outlines a little bit of how the law reform must be regulated. So you remember I talked about the bidding process before. the court said you have to make sure this is free and simple. Like you have for Indigenous peoples, they have to be able to enter into a process that isn't going to cost them anything, and it's going to be pretty straightforward. Next slide, I'll spend a little bit of time on because this gets into this pluralism and media piece that I, again, am most excited about. So the court actually, we mentioned those rights earlier, agreed with us as with the victims in this case, saying yes, we don't have a right to media in our convention, our treaty that we are following here, but we're going to talk about the right to media as it's discussed in the UN Declaration, and actually incorporates, I think, really broadens this idea of freedom of expression and includes this idea of media and pluralism for Indigenous peoples. And this is the first time globally that we think this has been done by an international court to look at this right to freedom of expression with regards to Indigenous peoples and talking about media, the right to media. And again, it's all kind of based and grounded in this idea of pluralism to ensure that there are plural voices out there. And in a country like Guatemala, like I said, predominantly, at least 50% Indigenous, to not have that voice is not striving for a pluralistic kind of viewpoint or diverse or inclusive inclusion in broadcasting. So this is what we're most excited. Again, like I said, we think it's the first time that the UN, that this court or any court or any body has looked at the right to media, the right to freedom of expression for Indigenous peoples and opined on it in a positive way.
Can I ask you a question?
Yeah.
With 50% of the population being Indigenous, how much of this effort of censorship is about the message itself to the people as a political voting bloc?
Yeah, I mean, I think
I think the fee cost is a mask.
yeah.
I'm asking if it's a mask for the message to be blocked.
I always feel a little uncomfortable answering that question because it's not like I have the data, right? Because you're talking, but you talk to anybody in Guatemala or most people in Guatemala, they say, absolutely. This is about, I mean, if you talk about exclusion of a people, not having them contribute or participate in media and radio, which is part of a democracy, right? How do you have a democracy if only half the population is able to share ideas and talk about ideas? Then yes, from their perspective, and I'm not Native, I'm not Guatemalan, I'm not Maya, I don't want to speak on their behalf, but from what they tell me, absolutely they feel this is part of, making sure their voice is not heard. And there are powerful individuals, corporations who have lots of money, who control a lot of the media in Guatemala and don't want to see this happening, right? Because that's going to eat into their share of the market, into their voice, whatever it might be. So to answer your question, from those that I talk to, yes, it's about continuing that historic oppression, historic exclusion of Indigenous peoples. Yeah. So when this came out, they were really, the judgment was a huge step forward. There might have been a hand back there.
You have a question back there?
Mhm. 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 Mm.
So just so I could repeat the question for the Zoom world, is it essentially, it sounded like a two-parter to me, which was, does the censorship around media and access impact the tribal nation sovereignty, maybe as a cause of action, maybe, or, something to string into a cause of action? But also what kind of entity or body can be formed internationally, maybe? Or knowing what's happening in other countries
Yeah.
here to help combat that amongst indigenous nations?
Well, I'll ask the second question, the second part of that question. There are there are kind of global organizations that focus on community radio, not specifically Indigenous community radio, but there are organizations that are looking at media for kind of community media, right? And community media has a specific definition. It's about a community having ownership and management of some form of media, or a radio station in this case, right? So I'm happy to kind of share that information. I'll point out that Cultural Survival, the organization that used to be Cambridge based, but now is kind of global based, does a lot of this work on community media around the world. And I can connect you with them as well. And you could, connect, there are lots of networks out there. Not so much here in the US, but, I can certainly connect you with others. The first part of the question, I had a thought too, but I've lost it. The one thing that came to mind when I was hearing you speak was there was an argument that we didn't adopt, but there were some folks that were trying to make the argument that radio frequency actually should be controlled. And I think this is to your point, controlled by communities themselves, right? It's a property. It's part of kind of their environment, right? So you think about property rights, land rights, they were tying that to kind of land, which I thought was fascinating. We didn't pursue that legally, but there's something to what you're saying. And I'm sure if you did a Google search, some of that might come up too. But this idea of radio, the frequencies themselves should be owned by communities, which I think is what you're saying. So there are people out there talking about exactly what you've talked about. I had a few other thoughts, but I think for some reason I've lost them. But I'm hoping that gives a little bit of food for thought in terms of that. What's different about Guatemala is this idea of sovereignty. Tribal sovereignty is very much, something that's based here in the United States. You don't hear a lot about it elsewhere. You hear about the right to self-determination. But again, it's for tribes here, it's unusual here in the US for compared to other parts of the world where tribes actually are able to exercise their right to self-determination in ways that a lot of indigenous communities around the world don't. So, Guatemala they have indigenous communities, they have their own elders, they call them ancestral kind of leaders who will govern, but they're not talking in terms of sovereignty, kind of in the way that we do here in the States. But yes, I think it's a really fascinating idea, and there are individuals out there who are looking at this idea of radio frequencies and having control over them because it's part of their space. So I hope that helps a little bit with your question, your comments. Yeah. Right. 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 Yeah. Yeah. Yep. Yeah. 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 And some of them. Yep. Yeah. 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 I mean, I don't know if it's on radio, but I think in other areas, tribes are trying to assert that sovereignty, that jurisdiction over kind of regulations of different areas. Yeah. And the Guatemala case might seem a little bit, it's from Guatemala. It's about radio. It might not be kind of the issues that we're faced here in the United States as much, but I brought up the case first just to showcase how advocacy can look internationally, right? And it's a little bit different, like I said, because we're at the court. But it can work, in my opinion. And for those of us here practicing in the U.S., and we do this work for for tribal communities here in the United States too, to look at the Inter-American system or the UN system. But advocacy internationally can really complement the work that we're doing here in the United States. But I have one more slide that kind of just shows the implementation piece. Actually, the last one I'll just skip to, but just to kind of show a little bit of the work that, you know, that we have to do following a judgment, right? So much of what we're trying to spend time on now is community outreach, educating communities about the judgment, doing some lobbying, building coalitions. I mean, it's a lot of this kind of legislative lawyering piece that has to happen. But yeah, it'll take a while. I think when the judgment came down in 2021 in December, everybody was so excited in Guatemala. They thought it was going to happen like that. 2 years later, we're barely have scratched the surface. And I've had to say from really day one, having done this for a little bit of time, say it's going to take some years. I know that doesn't sound right because it's not, but it's going to take some time, right? And it will. I'm hopeful we'll get there, but it's going to take a few years, and that's one of the downsides of this kind of change. But thank you anyway. I see one more question up there, but I'm done with my remarks.
We'll take one more real quick, then we'll switch while we get queue up Andy's PowerPoint. Go ahead.
Oh, I know. Yeah, with the president. Yeah. Yep. 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 No. Mm-hmm. 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 Yeah. Mm-hmm. 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 Mm-hmm.
So just to repeat the question, I think, Nicole, you can start and Andy, you can finish because I'm sure you can respond to this question if you are willing to, but the question is essentially with the rise in populism internationally, across nation states, undoing a lot of the progress that Indigenous advocates have fought for in international Indigenous and human rights. Is there an approach around a kind of a tandem approach around international advocacy and nation state advocacy to make sure the nation state is accountable to international human rights norms and laws and such?
Yeah, I mean, the simple answer is yes, absolutely. You can't really pursue an international strategy without first pursuing domestically. I mean, there are actually requirements before we could go to the Inter-American Commission on Human Rights. We had to exhaust domestic remedies. Otherwise, we couldn't get in unless you can show an exception. So and that's part of the system as well, right? The international system wants you to pursue things nationally first, right? Because nations have these obligations under these treaties. They want nations to solve these human rights issues first. So you absolutely have to go national as well. And I think this is one of my points early on was you can complement that with the international work as well. I mean, they really do go hand in hand. And so when we think about a strategy for a community that we're working with, we try to think about how our work can complement the work that's already being done domestically. We obviously don't want to infringe or hamper that work that's being done domestically. And then ultimately the international work that you are doing, and you get some really good, whether it's a report or a concluding observation or something in an annual report, you're going to use that and bring it back nationally and have that conversation. So I absolutely agree with what you're saying. You have to do both.
All right, great. So Andy's response will be part of his presentation anyway. So I'm going to queue up Andrew's PowerPoint. And while we're doing that, just a brief intro and him. All of our presenter bios are in the agenda, and I'm sparing me reading to you. But the Andrew is, as I mentioned earlier, co-counsel on the Onondaga Nation case right now, and among many other things which he'll speak about in his work, and comes to us from University of Denver, where he teaches. And so while we're queuing that up, there we go. Andy, take it away.
All right. And I'll stand so I can see my own slides. I don't know what I have there, but oh, I can see that. Yeah, they didn't have full screen. And for those of you, it's a small screen here. If you want to move forward, you can see it better. I have a lot of slides, and we started a little late, and so I'll try to run through these fairly quickly. I'm an attorney. I practiced federal Indian law for about 40 years, and for the last 10, 20 years, I've been doing focused mostly on international work. I was a civil rights lawyer, also environmental lawyer. If you practice Indian law, you usually end up practicing natural resources or environmental law because, at least in this country, in most countries, Native people aren't really people, they're natural resources. And so it's just like the peoples of Africa were human resources, the peoples of the Americas are natural resources. That's why you find Native people in the Department of the Interior, whereas they used to be on the Department of War. So we deal with Native peoples as natural resources to be exploited. Slide. So good morning. And Lakota is Heiani Washte. Where I come from, I work mostly with the Ochechi Shikoe Oyate, which is the 7 council fires of the Great Sioux Nation, what we call the Great Sioux Nation. Sioux is the colonial word. It's the Lakota, Dakota, and Nakota people of the Great Plains side. And I also wanted to recognize the area that we're in. When I first started preparing for this, I read up on who were on the history of the Native peoples of Rhode Island, and discovered that, at least according to Wikipedia, Roger Williams had met with the Native people, and they agreed to let him buy some land, and he bought this area. And then I spoke with some people from the area and they said that's not really how it is and what happened. So I wanted to recognize that we're in the, what is it, the Swamis territory, which I also looked at that. And that's also called the Wampanoag Confederacy. And also learned that that's also a colonial word. So, but that the Confederacy was a confederacy of some 30 Native nations that formed prior to the really prior to the invasion of this area, and that the specific area that we're in is the Pokanoket. And I'm language challenged, always have been my entire life, so it's kind of an ironic that I end up in this position. So I apologize when I butcher words. Slide. So I also wanted to honor the peoples of this area, the indigenous peoples, particularly the ones that I work with. So it's the Taino. And I just, a few months ago, I came back from Jamaica after 2 weeks with Francisco Kelly, and touring the indigenous peoples of Jamaica. One of those was the Taino community, and that's the Kaisike of that community there and his family. And we also met with the Garifuna, the Garinagu, who are the original, they're originally from St. Vincent, and then they were forced off the island by the British and resettled along the coast of Central America. I'm actually counsel for the Garifuna Nation, and they're trying to reform and reclaim their sovereignty of that area in Belize, and we're putting together litigation first to file in the Supreme Court of Belize, and then in probably in the Inter-American Commission, because they also haven't signed the American Convention of Belize, to follow up what the Mayans did there and reclaim their territory and exercise their autonomy and sovereign rights. The one on the other side there is one of the first delegations of the Maroon peoples of the Caribbean. They're people from Suriname, and I can't see my slide, but they're people from Suriname, Trinidad and Tobago. We had somebody from the Americas and Jamaica and other places that are part of the Maroon communities. The Maroons are descendants of the escaped enslaved people from Africa. And one of the interesting things I would say about them, and by the way, before I get on that, the Garinagu have, a lot of them have migrated. So it's a diaspora not only to the coast of Central America, but also to the New York area. And there's some 100,000 or more Garifuna, I believe in Brooklyn and in that area. So including the president of the Garifuna Nation is up there. And so it's a big contingency up there. Well, for the Maroons, they have communities throughout the Americas, including, for example, you've heard of the Black Seminoles and so forth. Those are Maroons, the alumni, and other peoples of the Black Creeks and so forth. A lot of those have maintained their Africanness. The people from Africa are indigenous peoples. And so we talk about Black Americans or Black people here, but they're really indigenous peoples from Africa. And the ones that have lost their indigeneity have a racial status, but the ones who have retained their indigeneity have maintained their sovereign status as peoples from Africa. And so one thing I've been working with for the Maroons is to gain recognition as indigenous peoples in the Americas, but not indigenous American people, but indigenous African people. And I use the K in African for indigenous peoples from Africa. And so there's a book coming out on this. I have a book chapter in that where I do the legal argument for that. We made presentations to the UN. The slide, which hopefully they'll pull up soon, has a delegation that we put together for the UN Permanent Forum on Indigenous Issues that they went to in 2019, and it followed up on that. So if I could get the next slide. I teach at the University of Denver. I teach the Indigenous Peoples human rights and the human rights courses in international law. I'm part of the human rights program. I'm also the last standing faculty member of the Indian law program that we used to have there. I've been teaching there over 10 years. Everyone that's left, they no longer fund that program. But the law school, the school and the law school started out of the Sand Creek Massacre. It was born from genocide. The founders of the school, John Shivington and John Evans, were the leaders of the Sand Creek Massacre. It's infamy. And they have a founders celebration. The mascot for the University of Denver is the Denver Pioneers. Pioneers is just another name for ethnic cleansing. And so I work with the Native students there. I have a paper actually coming out sometime soon on that, where I criticize different educational institutions, universities, for maintaining their colonial roots. And for the University of Denver, the title of my paper is called "Celebrating Genocide," and because they won't release themselves from that moniker of pioneers. Next slide, please. And so today I wanted to honor a friend of mine, Rudy Reiser, who was the Center for World Indigenous Studies, who's a Native person, ex-professor that died recently, and he passed on. And but he was struggling. One of the things he was trying to do, and this addresses one of the questions earlier, is that he's been trying to create an international criminal court for violations of Indigenous people's rights, so that you can. He's been working with the people from Armenia, and the people from the indigenous peoples of Iraq and those areas who have suffered so terribly. And he's got a 20 or 30 indigenous groups of indigenous nations and so forth to sign on to creating this new court. And he's proposing to create it outside of the UN. So it would be a body that's controlled by the states that sign on to it and by the indigenous peoples themselves. But that's one remedy to deal with this issue about international human laws not being enforceable. It's also, I wanted to honor Leonard Peltier, who's now 48 years in prison as a political prisoner out of the Lakota struggle and Wounded Knee. It's also the 50th anniversary of Wounded Knee, of the Wounded Knee occupation, and we had a celebration down there as our ceremony. It's the 200th anniversary of the McIntosh case, of the creation of federal Indian law. 2023 is from 1823 was the initiation of the colonial rule over Native peoples. And also wanted to honor the Palestinian struggle. The Palestinian people themselves identify many of them as indigenous. They sent a delegation up to Standing Rock, and they identify their experience as very analogous to that Native people have experienced here. Next slide. So my mentor, Vednanda, he's up there in the corner, once put me on one of these panels as a respondent. International law panels, they always have a respondent who's supposed to say important things about the presenters. And he said for me to say something insightful. Next slide. I misunderstood. I thought he said insightful. So that's kind of my approach to these things, is I tend to be insightful. So I apologize ahead of time for some of what I'm saying. Next slide. One thing I always say, particularly to my Native audience or the Native people I work with, is don't trust lawyers. Just don't trust them. By the way, I don't have this down there, but I was going to add some stuff in there about what lawyers do in this country. Lawyers swore to uphold the Constitution. Think about this. Every lawyer in the country, including those that represent Indian nations, Native nations, swear to uphold the Constitution. Not only the Constitution of the United States, but the Constitution of each state that they're in. It's usually the states, for example, the Indian Child Welfare Act, that's violating the rights of Native people. So there's a conflict. There's an immediate conflict of interest for every lawyer representing any Native nation in the country. Conflict of interest, and there are ethical rules against that. And so I violated my rules of ethics for the last 40, 50 years. The other thing I tell I tell the people, my Native audience, is that question everything, think for yourself. Don't let lawyers tell you what to do. Next slide. And so what we're dealing with here is federal Indian law. And there are two issues there. This is not the law of Native peoples. This is the law of the imperial ruler over Native peoples. This is their law. This is not law binding on Native peoples. This is the law that the imperial powers put against itself, binding its behavior and the way that it approaches in its relationship with Native people. So federal means the US, it doesn't mean Native nation. Indian is a racist term. So it's a way that the imperial power, the colonial power, is going to rule over a race of people that was found within the territory which it's invaded. And so it's developed this set of laws, starting with the Leyes of Burgos with the Spanish, and then moving on into the original laws here were military laws that told Native people they couldn't practice their religion and so forth. They were prisoners of war. Next slide. So, and of course, the father of federal Indian laws is the great Chief Justice John Marshall. Started with the McIntosh case in 1823. And so the great Chief Justice John Marshall was next slide, a pervert. All right, next slide. He perverted the course of justice. He perverted justice. And next slide. And there's really no question on this. All of us who practice federal Indian law know this, right? He took things like the doctrine of discovery, which is a rule of international law that said that if an area was unoccupied, that you could take it. People say we want to get rid of the doctrine of discovery. Well, the doctrine of discovery is not the problem. It's the way it was perverted by the high imperial court of this country, by Chief Justice John Marshall. And so he perverted it, and he created the doctrine of discovery, the trust doctrine, the plenary power doctrine, out of whole cloth. But all of them, it wasn't, they say out of whole cloth, they call it a sui generis, which means standalone law. It's a law that only applies to Native people, which means it's racist to begin with at its roots, ab initio. Sui generis, and it's in the opinion. This is the law that only applies to this race of people, right? It's racist. And so next slide. And so under the law that he created, human beings became less human. Nations became and peoples became non-existent. And this is in his opinion. We're going to treat them as not existing, not residing in the areas in which they have occupied for thousands of years. The doctrine of discovery under the law of nations became the doctrine of imperial and Christian theft. And the law of occupation, and there is an international law of occupation, which I practice, under the law of nations, became the doctrine of imperial and racist domination, also known as the trust doctrine and the plenary power doctrine. So next slide. And so this is a quote from John Adams, which he says, "How strangely the tools of a tyrant pervert the plain meaning of words." And so John Marshall was a tyrant who perverted the plain meaning of words of the existing international law. And that was the international law of Europe, by the way. It was not the international law of Native people. So he perverted his own law. It's great if you ever have the time, look at the Law of Nations by Emerson Vattel. Vattel is cited in McIntosh. So that was the book that everyone read on international law at the time, Vattel. And Vattel talks about all these things. And so these things already existed. International law didn't come into existence after World War II, right? It was in existence well before the time of the McIntosh. And so he misapplied, he perverted international law in order to create this separate racist law. Next slide. And so, there's a connection then between, and I work both with the descendants of the enslaved peoples of Africa, and I work with the First Nations peoples here. I work with both. And a lot of people, they separate them. They think they're distinguished, that they're different peoples, but they're not. And we could see that both in the Chief Justice that succeeded Chief Justice John Marshall, and that was Chief Justice Roger Taney, who wrote the Dred Scott opinion. And if you haven't read that, I encourage you to read that, because Dred Scott also talks about the status of Native people, of Indian people, and he compares Native people to Black people and finding that Black people were chattel property. Next slide. But it turns out that it's a shared colonial experience. McIntosh held that Native people were less than human and that they were colonial property, that they're natural resources. Dred Scott, with Justice Taney, found that enslaved Africans were less than human, but they were also colonial property. They were human resources. So both of them are tools of colonial rule. Next slide. So, and so it's a supreme injustice. One thing that was interesting is that John Marshall, at the time of his death, owned 200 slaves. Think about this. This is a guy that's writing, that's considered the greatest Chief Justice of all time. He owned 200 slaves. Can you imagine having 200 people taking care of you? Why do you need that? And Taney was also a slaveholder, and he wrote the Dred Scott decision, right? They're corrupt. They're corrupt at its roots. Next page. So, and we see this, and so that was hundreds of years ago, all right, 200 years ago. It's still alive. This racist law that was created 200 years ago is still the law of the land today. Everyone gets excited about the NHL Welfare Act decision. You should read it. And you should read the briefs by the Native American Rights Fund or the National National Congress of American Indians and the other briefs in that, right? Not one brief was filed that raised the colonial relationship, that raised the denial of human rights. Not one brief challenged the United States and its control over Native people in terms of the theft of Native children, which is the theft of the future of Native peoples. Not one brief. All of the briefs they originally used the plenary power doctrine, which they were hiding behind the fact that they were occupied peoples and that they were subject to colonial rule by saying the federal government has colonial rule over it to the exclusion of the states. And so the states can't come and take our children because we're subjects of the colonial power of the United States. That's a plenary power doctrine. They hid behind that. And if you read the Brackeen decision, which is the one on the Indian Child Welfare Act, Justice Barrett and then particularly Justice Gorsuch, who's from Boulder, where I'm from, Justice Gorsuch, they spend the entire argument on the plenary power of the United States as fulfilling that area of regulating, controlling Native people. And they say, well, we have exclusive rule over Native people, therefore the states can't come in here and pass laws to take Native children because that's our rule. And so, and then you find all these Native people that are under the rule of the United States, some 500 nations, Native nations, tribes signed on with the NARF brief, and they hid behind the trust doctrine. Well, what's the trust doctrine? Trust doctrine says that Native people are incompetent savages and that they can't rule over their own lives. That's the trust doctrine. Read it. And so today, Native people are still incompetent savages. So because they're incompetent, they can't rule over their own affairs. And so the federal government, colonial rulers, going to do it for them. That's the trust doctrine. That was the argument that was used by the lawyers for 500 Native nations before the U.S. Supreme Court in the Indian Child Welfare Act. So, yeah, so keep going. Next slide. And the McGirt decision, everyone gets excited about that. The McGirt decision was the one that said that the Ocmulgee Creek nations that the jurisdiction still survived because the territory had not been expressly taken by the U.S. Congress. All right. And so everyone was saying, oh, it's a great decision because it recognized the treaties and it said that it recognized the territorial jurisdiction. Still survived despite the fact that the federal government had destroyed the government, had destroyed the court system and implemented a colonial court system, had taken all their lands, had destroyed their culture, destroyed their language. Despite all of that, the territory still existed, and therefore the jurisdiction, the state did not have jurisdiction then over that territory, and so they threw out a murder charge because they in state court. And so everyone got excited about that. They said, yeah, it's an affirmation treaty. When you go down in this by Judge Gorsuch, go down and you read the very last paragraph or so of that. And he says, yeah, the treaty still exists, but Congress can abrogate it at will at any time they want. Plenary power doctrine. So it was not a victory at all because of that qualifier. Next slide. And then here's a case that kind of snuck under recently, this last term, 2023, same time as Brackeen. It's a case by the Lac du Flambeau tribe where they were trying to argue, well, they shouldn't be subject to the bankruptcy code, U.S. bankruptcy code. It's the general law of bankruptcy law. It doesn't say it's not a law for Native people. Well, in this case, the High Court of the colonial power, the U.S. Supreme Court, held that a general law of Congress applied to a Native nation. It was a bankruptcy law. So what they're doing is they're extending the general laws of the country to it. It'd be like us extending our bankruptcy laws to Mexico. It is simply a huge violation of the relationship that have been created over the last 200 years in federal Indian law. And so if they can extend a general law, which doesn't even mention Native people, there's no mention in the bankruptcy code of Native nations or tribes, no mention at all. And they extended it under this decision just a few months ago to a Native nation. So that means think of all the general laws now that they can extend now to Native nations under this rule. I haven't heard anyone say anything about this case. Next slide. So we have a term for this. It's called lawfare. It's a fairly recent term, but it's using the law as a weapon of war, a weapon of engagement in war. Okay, next slide. All right. When was this? 1835. De Tocqueville, who was a philosopher and a young guy from France, came to the United States. He wanted to study democracy. So he writes a book on this called Democracy in America or something like that. Yeah, after he visits, but he happens to come in at the same time that President Jackson is moving during the removal area, moving the Native people from particularly the Cherokees and Creeks and others from the east down to Oklahoma, where I grew up. And so he's watching this. It's the Trail of Tears. We've all heard about it. You know, thousands of people died on the way. It was during the wintertime. He watched this. And so he makes this comment in his book, and it's a wonderful quote here. He talks about how the Spaniards, and this isn't exactly true, but this was his understanding, the way they got rid of Native people is they just lined them up and shot them, or they just killed them, just killed them outright. That was the Spanish solution, right? He says the Americans could commit genocide in a much more sophisticated and legal way. They simply passed laws to exterminate Native people. And that's lawfare. And so this is one of the early comments on, and he says, let's see if I get this quote here. He says, the Americans of the United States have accomplished this twofold purpose with a singular felicity, tranquility, legally, philanthropically, without sweating blood, and without violating a single great principle of morality in the eyes of the world. It is impossible to destroy men with more respect of the laws of humanity. Next slide. So what I'm getting at then, and the reason why I'm going through this, is to say why international law, which is really the theme of my talk, right? It's because, and we need to understand, they don't discuss this in law school. You take a federal Indian law program, and they have 100 or so in the country, right? You go to any of these law schools. They don't teach in those law books I just showed you. They don't teach this colonial relationship, not outright, not up front, right? They essentially teach within a box. So they want all the lawyers to operate within this colonial box where you're actually agents of the colonial system. You're agents of institutionalized and systemic colonialism and racism, which is what federal Indian law is an expression of. So when you practice that, you're doing the imperial powers, the colonial powers bidding. Think about that. So anyway, so the issue then, real issue here is colonialism. Next slide. And it's defined as domination, one power over one nation over another nation. Next slide. So in settler colonials, this is a line from a guy named Patrick Wolf. He was a professor that wrote about settler colonialism, right? And he identified settler colonialism as at its root, it means to remove, to replace. So it's ethnic cleansing. And he also said it's not an event, it's a structure. Settler colonialism is a structure. The structure of settler colonialism in this country and in most countries is in federal Indian law. They have a federal Indian law in Australia, they have one in New Zealand, they have one basically everywhere. Next slide. And so I call it the law of colonial domination or a law of slow genocide. To me, it's a law of slow genocide. You can line somebody up and shoot them, kill them all at once, or you can kill them over 200 years. by forcibly assimilating them. You have a policy that gradually assimilates people, destroys their culture, destroys their language, destroys their identity, corrupts them. You can do that over 200 years. By the time you've destroyed their identity as a people's, identity as a citizen of a people's, by the time you've done that, you've committed genocide. And it's even if it takes place over 200 years. All right. A friend of mine, Peter DeRico, just came out with this book called Federal Anti-Indian Law, which should be a required reading for every federal Indian law course in every law school. Next page. And he was a professor at the university. So let's talk about the rights of indigenous peoples in under international law. Next page. And next page. We're talking about indigenous peoples, and we talk about this concept of a nation-to-nation relationship. Next page. Which invokes the law of nations. All right. If you talk about a nation-to-nation relationship, you're not talking about going to the U.S. Supreme Court. That's one party to a nation-to-nation relationship. If you have a contract, if you have a relationship, you don't have one party deciding who. If you get into a prize fight, you don't have one fighter decide who's going to win that fight, right? You need an independent outside body. So that's the international law, the law of nations. The United States Supreme Court should have no standing to decide any treaty between any native nation in the country. Next page. And so the issue is not whether you're indigenous or not. The issue is whether or not you're a peoples, because your rights come as a peoples, and that's with the S. And this is a fairly new concept that's been developing. There's some books out on the law of peoples and so forth. But the S is really an expression of sovereignty. If you're a people, you're a group without the S. If you're peoples with the S, right, then you have certain rights under international law that come with that. Next slide. And one of those rights is sovereignty. If you're peoples, you have a right of sovereignty. Next slide. And sovereignty means the right to self-govern, right? Next slide. And that's expressed through the right of self-determination. And the definition here is a definition of self-determination that you'll find in all international human rights documents. And it's basically that you have a right to freely determine your status as a people, freely determine your status as peoples, whether you're an ethnic community, whether or not you're an autonomous community, whether you're not a separate nation, whether or not you're part of a confederacy. Those are all rights that you have under the right of self-determination, and that's a right that applies to all peoples. Next slide. So as part of your right, expressing your right of self-determination, you have the concept of nation. Next slide. You create a nation, and a nation has a territory. Right of self-determination means you have a domain that you govern. Vattel talks about a lot of this in the Law of Nations, and you govern that domain. And this gets back to one of those questions about developing, how do you deal with this radio station? You know, is they should have autonomy over their domain, over their territory, and they should be able to pass their own laws regulating their own radio stations. By the way, I wore this today for my new friend here, Nicole, because this is a radio station in one of the peoples I work with, the Sicango Nation, which is a Rosebud, quote, the Rosebud Sioux tribe. And they have a radio station there. One of the earlier ones is another group of people I work with, the Oglala Lakota Nation, which is the Oglala Pine Ridge Reservation. And they have one of the first radio stations there in the country, Native Nations. It's called Kili, K-I-L-I radio. You can go online and listen to it online. But you drive anywhere in western South Dakota, and you will hear Native drumming, and you'll hear singing, and you'll hear Lakota spoken over the airways. To all these Wasichu, all the white people in the area, they listen to that along with their cowboy music. They hear this drumming, and they know the Native people are coming for them because they're living on Native land. Next page. And that was started by the American Indian movement, by the way. And out of this concept of self-determination and sovereignty comes this right that we talk a lot about, free, prior, informed consent. The right of consultation comes from that imperial relationship. You consult with somebody that you govern over, right? But don't confuse consultation and consent, right? You can consult to get consent, but consent is a power, is a right of a peoples that they have to control over their own destiny. Next page. And so the other thing that you get with sovereignty is you get the right to have your own laws. These are called customary laws. And there's a whole, I can go into it, but there's a whole developing law within the international communities as well as within domestic communities. Canada is really big on this right now with the Delgumet decision, but recognize where the courts of those nations are recognizing the customary law of Native nations, Native peoples, right? It's very big. So if you're a Native person, where do you turn first? Do you turn to the law of the colonial ruler? Do you go into state or federal court or even international? No, you turn to your own laws, right? You turn to the laws that govern your community and your peoples. And so it's a way of decolonizing is starting to recognize it. Now, what do we mean by Native laws? It's just customs and norms. Native people did not have to write down their laws. In the Delgumet case, which I just mentioned in Canada, the Canadian Supreme Court said that the songs, the dances, the totem poles, the stories that the Native people had, those were their laws. Those were their laws. And they were just as powerful and deserved just as much credibility as the laws that were written down by the Canadian Parliament, whatever. So the custom is the source of law. The other thing I want to mention is the concept of chthonic. The Native law has been described as chthonic law, which I like. Chthonic means from the earth. And so what it's recognizing is the attachment of Native people to Mother Earth, the grandmother Earth, Nchimaka. And so that their laws, what they believe in, their norms and their customs come from the earth, that they are earth peoples. And so that's this concept of chthonic law. Next page. All right. And so I just wanted this slide just to show that Native people have an international law, right? You have it with these confederacies. The Chechichicoan is a confederacy of the 7 council fires. You have and there's 3 other confederacies, including the Haudenosaunee, which I work with, where the Onondagas are a member of the 6 Nations Confederacy. Next page. And so I want to, and I'll try to speed up on this a little bit because I realize we're going to be short of time. I'm probably over already. But the sources of international law that we look at are treaties, custom. They have customary international law, which is different than customary law. Customary law deals with indigenous law. Customary international law is the custom of nations. What do nations do generally? Without signing a treaty. Customary international law existed prior to treaties, and treaties generally grow out of the customary law. So they grow out of the custom of nations and states. And so you get an agreed, let's say the nations generally agree that we're not going to execute children anymore. It becomes customary law, and then you can pass a treaty that says we're not going to execute children, right? So, and then they have general principles of law. Some of those are what we include what we call fundamental law, fundamental rights. And these are a lot of, they're rights that exist outside of international law. They're existential rights. Sometimes we call them inalienable rights. You see them in our US Constitution, the inalienable rights of life, liberty, and the pursuit of happiness, right? Or property. Some people throw property in there, all right? They also include the right to equality, which is important for Native people. And they include the right to liberty, which is important to Native people. So, and those actually are bounding on all states, whether or not you agree to it or not. Under international law, you have to obey it. And under customary law, I'll get to that in a minute, but anyway, and then you have judicial decisions and verdicts. Next slide. And so we have this natural law, which I just mentioned, which are the inalienable rights and the fundamental rights, right? Those are the primary rights. They're existential rights. They come with your existence, and no one can take them away from you. No one can pass a law, for example, to legalize slavery, right? It can't be done anymore because it violates a fundamental right. Next slide. And some people are saying the right of self-determination now is a fundamental right. Now, next slide for customary law. Keep going. The most important part of customary law is the law is called a jus cogens right. And a jus cogens right is a norm of customary law that is so followed, so agreed to that no one can disobey it. It's very close to a fundamental right, right? But it's human created. It's an agreement of people. A fundamental right is created by nature. It's created by your existence. These rights are created by man. They're called positive law. And so you have these rights, jus cogens rights, and that includes, next slide, that includes things like slavery is now a jus cogens right, genocide, all right, and some other things like that, even self-determination. Right against colonialism now is a jus cogens right. So practice of colonialism against any peoples is a violation of customary international law, the most powerful forces. And there's actually a treaty, it's under the, it's called the Vienna Convention on the Law of Treaties, where they have a provision where they describe jus cogens rights, and says that no state or even a treaty, no treaty can be passed that interferes with those rights. Next slide. And erga omnes is just talking about state responsibility that the states have to require. Go ahead, next slide. Try to skip through some of these. Treaties are the positive law, man-made law that you have to go by. Next slide. And so I mentioned the Vienna Convention law. So when you talk about treaties between native nations and another power, it should be governed by the Vienna Convention on Treaties if we're going to follow IACHR or Western law, European law. It should not be governed by the Supreme Court. If the United States and Mexico sign a treaty, United States and Canada sign a treaty, it's not governed by the Supreme Court of Canada or Mexico or the United States. It's governed by an independent body, independent rules, an international body, which is the Vienna Convention on Treaties. So that's where all these treaty cases actually should be argued. Next slide. Keep going. And that one's simply saying federal Indian law is the law of occupation. The United States is a successor colonial state, right, and an empire. The United States received its authority, so-called authority over native people from Spain, right, from France with the Louisiana Purchase, and it got some of its own, but it rules over 530 plus native nations, rules over them, right, which makes it an empire. It is the United States empire, right? Puerto Rico and Guam are not the only colonies of the United States, Virgin Islands, right? There's 500 plus. Keep going, colonies. Keep going. All right. So if we're really going to talk about federal Indian law, we're talking about federal colonial Indian law, right? Where the doctrine of discovery is the doctrine of the non-existence of native people. The trust doctrine is the doctrine of incompetence of native people. And the plenary power doctrine is the doctrine of absolute power and authority over native people. Next slide. All right. Now, talking about colonialism and international law. Before the 1960s, since the 1950s, the international community, I'm talking about the United Nations and even before the United Nations, colonialism has been banned as a settled matter of international law since the 1950s. And they passed a declaration on the eradication of colonialism. We're now in the fourth decade, 40 years now, of the UN calling upon all the UN member states around the world to immediately eradicate all forms and manifestations of colonialism. Next slide. And these are some of the resolutions here. The main one is Resolution 1514 from 1960. This is a General Assembly resolution, means it was passed by the UN General Assembly overwhelmingly. And it calls for the immediate ending, and it quote, all forms and manifestations of colonialism. Federal Indian law is a form and manifestation of colonialism, right? And then I'll tie this into what we're doing at the Inter-American Court Commission just said. Next slide. And so it violates the right of self-determination. That's the main fundamental right colonialism violates. Next slide. It's also a racist law. Next slide. It's structural racism, structural colonialism. Next slide. And so it violates the UN Declaration, a UN Convention on the Elimination of All Forms of Racial Discrimination. And in fact, and we've signed, the United States has signed and ratified this treaty. This is an enforceable treaty that the United States has signed and ratified. Now it says it hasn't implemented it, but under the Vienna Convention on Treaties, they can't do anything in contrary to the treaty, even if they haven't implemented it. You follow me? And so this one in the preamble adopts that UN Resolution 1514 calling for the end of colonialism from 1960, right? In addition to that, it identifies colonialism as a form of racism, right? So it ties it all together. And this is an enforceable treaty. In fact, it was enforced in the Mabo case, MABO case in Australia, this treaty, where they threw out the doctrine of discovery. Next slide. The charter. No, I said you get your rights from as from the concept of peoples, not being indigenous, but you are peoples, right? The charter itself, which is the constitution of the world, right? It's where everything starts from, declares at the outright, all peoples and nations, large and small, are equal. And that settles it right there. Next slide. And that's where the UN Declaration of Rights of Indigenous Peoples also gets its declaration. Next slide. At the very beginning, where it declares indigenous peoples are equal to all other peoples of the world, and they have equal human rights of all other peoples of the world. Where does this come from? It comes from the UN Charter. Is the UN Charter a treaty? Yes. Is the UN Charter enforceable? Yes. Is it binding on the United States? Yes. If the United States wants to remain a member of the United Nations, it has to obey the Charter. Next slide. These are some of the collective human rights of Native peoples that are laid out in human rights. And next slide. So one thing I will say about the Declaration of the Rights of Indigenous Peoples, which we call the UN DRIP, it did not create any rights. It did not create any human rights. It simply declared that those human rights that were possessed by all other peoples of the world are also possessed by the indigenous peoples of the world. That you cannot discriminate against indigenous people. It's racial discrimination. And so you cannot, and so it simply extended those same rights. So those rights already existed because indigenous peoples were a peoples. So in this area in the Americas, we have the OAS, which is similar to the UN, but it's the UN for the Americas. Next slide. And there they have what's called the human rights in the OAS Charter is recognized. And this is important because this is where you get your enforceability in these cases, right? The UN Charter, if you're going to be a member of the OAS Charter, if you're going to be a member of the Organization of American States, which the United States is one of the founding members, right? You have to agree to recognize and enforce human rights. It's in the Charter. It doesn't say which human rights, it's just human rights. Next slide. So the human rights are found in a document that was adopted at the same time. It's called the American Declaration on the Rights and Duties of Man. And I won't go into it too much, but what happens is in these cases for the Inter-American Commission, like the Dan case, and like our case right now with the Onondagas, is they're able to enforce this against the United States always says, oh yeah, the declaration is not enforceable. Because it's a declaration, it's not a treaty, it's not a convention. And so they say it's not enforceable. Well, the response to that by the commission and the court would be, no, this is a document that lays out the human rights that are mentioned in the Charter. And the Charter is a treaty, and the Charter is enforceable, right? And so it says, yes, we have these decisions that say, sorry, the United States is bound to these. So yeah, you can go to the next one. So the other document they have is, and it creates the Charter, by the way, it creates the Inter-American Commission on Human Rights. Next slide. Then you also have the American Convention, which was passed later, and it created the International Court on Human Rights, or the Inter-American Court on Human Rights. Next slide. And then after that, they passed, just like the UN draft, the American Declaration, which is slightly different than the UN Declaration, but it's similar. Next slide. All right. Now, the purpose of this slide is just simply to say that there are quite a few cases now. There's probably 20 or so cases now that have been decided either by the commission and the court that recognize the sovereignty, the rights of indigenous peoples, Native peoples of the area. The Saramaka case is important because it involves the Maroons. In the Garifuna case, there are 3 or 4 now in Honduras that recognize the rights of the Garifuna people to their communities, just like the Mayan case in Belize, to rule over their areas and to have, they recognize, for example, the communal ownership of their property. So they're rejecting Western property rights. Next slide. And in fact, in one of the Garifuna cases, they actually told the nation of Honduras to remove the invaders from their territory and to pay them for the titles that they gave them to their land. And for one of the Garifuna cases, it actually extends out into the ocean, and they have ocean rights, autonomy. That's their territory is defined. And so these Inter-American Commission and court cases talk about the demarcation of their territorial boundaries. So they recognize their right to rule, the right to govern, and all that. That's why these are important. And so I got to read what oh, this is the Dan case. All right. That was mentioned earlier from 2002. This is a merits decision in the Dan case. So this is the first decision in the Inter-American Commission where the United States have been called to task for what they did. And in the Dan case, a bunch of people moved into the Western Shoshone territory, and the federal government refused to remove them and didn't remove them. And so it went all the way up to the U.S. Supreme Court. U.S. Supreme Court said, we're not going to remove them, we'll just pay you for the land that they took. They refused to take the money. And so then they went on to the Inter-American Commission, said that we have a right to get our land back, not just money. And the Inter-American Commission agreed with them. And the case was started by two elderly sheep herders, Carrie and Carrie Dan and, Mary and Carrie Dan. Yeah, beautiful people. And what they would do is the National Forest Service had taken some of the Western Shoshone land through the various allotment acts and so forth, and had taken them and created a national forest out of it. And Mary and Carrie Dan knew that it was their ancestral treaty lands, Ruby Valley, and so they would simply move to graze their sheep on there. The Forest Service would take their sheep and went back and forth. Finally, they went all the way up to U.S. Supreme Court, lost and won in the Inter-American Commission on the right to property, right to equality, and on the right to an effective remedy, or because they were saying that it was not an effective remedy if you can only get money back rather than your land back, which is, next slide. So we followed up from this case. I don't know if I'm getting into, next slide. All right. So this is our case. And basically we bootstrapped what had been done in the Dan case. That was 2002. So nobody's won anything against the United States in over 20 years. So this was filed in 2014. So it's taken how many years now? 10 years, just almost 10 years, just to get a decision whether or not they're going to take the case. The first decision they make is whether or not to admit the case, meaning they're going to take it. Next decision they get is just what they call a decision on the merits. And that's on whether or not you're right. Usually if they take the case, it means you're right. So you're probably going to win on the merits. All right. So we just got this decision out in May. And we're preparing supplemental documents and so forth to support the decision on the merits. It was a good decision because it involved 2.5 million acres of land that was stolen by New York State from the Onondaga people. Next slide. And so there's a little dot there in the center, that's the Onondaga Nation, but it was all that big area near Syracuse, north and south of Syracuse and stuff. And they're part of the Haudenosaunee Confederacy, which is also a party to our lawsuit. And so they're arguing that 2.5 million acres were stolen. Next slide. And it was stolen in the 1780s through about 1830. All right. And on that area was this lake Onondaga, which is in the middle of Syracuse. Right. So the largest mall, I think, in America, or one of them, is right on the lake, sitting on top of toxic land. And it was used as a toxic dumping ground for 100 years by corporate interests. Next slide. And it's now a Superfund site. So they argued the denial of the equality because they didn't have the same rights as non-native people to get their land back. As a denial of the right to a fair trial or protection, because that also was denied them solely because they were native people. And then it's a denial of the right to property. And these are the same three rights that were raised in the Dan case. One of the distinguishing things between the Dan case and the Onondaga case is the Dan case was brought by two beneficiaries of a treaty. The Onondaga Nation is the first case against the United States brought by a native nation that has gotten admissibility. Next slide. And so that's the admissibility decision. Next slide. And so this is starting to get some press, but it talks about the groundbreaking issues that are here. Next slide. All right. Now, one of the issues that they denied on was the right to property. And one of the things they said was it's too late. You know, the property was taken in the 1700s. What's going on? Now you're suing. Of course, we made the argument that you can never sue because the government didn't recognize the right to sue. First off, they didn't recognize the existence of native peoples. Then they didn't recognize the right to sue and so forth, so forth. And we go through the long history on that. So we're filing a motion. One of the arguments we made, and this is settled law in a lot of the Inter-American Commission decisions, is that the taking of property is a continuing act. It's not something like settler colonialism. It's not an event. They didn't just take the property in the 1700s. They occupied the property. They denied them the use of that property. They denied them the access to their sacred sites, denied them the resources and so forth. Then they went in and they contaminated the hell out of it, right? So it's a continuing tort, continuing crime. And so we're asking that they reconsider this. And in the motion for reconsideration, we're attacking the United States head on colonialism. We're attacking colonial rule. We're attacking the doctrine of discovery. We're attacking the doctrine of plenary power. We're attacking the doctrine of trust authority and dominance. And so it's head on, and we're raising all of the international law regarding how colonialism was banned globally by the international law, international community, for over 60, 70 years, right? And so it's settled law. And so it'd be interesting to see now and my understanding, this is the first time any litigation internationally or domestically has been able to raise this directly to the court or commission, the tribunal. And so we'll see what happens. We'll see what happens on this. Next slide. All right, so I'll go through these. There are other international remedies, and Nicole mentioned some of them. Precautionary measures, next slide. You have special rapporteurs, next slide. You have the United Nations Human Rights Council, next slide. And by the way, Hawaii, the government, the Kingdom of Hawaii now is before the UN Human Rights Council, arguing that their islands are illegally occupied. And they're not using the law of occupation under colonialism. They're using the law of occupation under war. It's called humanitarian law. They're two separate laws. They're similar, but they're different. And so they're using the law of war. It's interesting to see where they're going. So finally, I'll end this with the concept about restorative justice, which I know most of you are engaged in. Next slide. It's a process of decolonization. You have to recognize that when you're engaging with the United States under any matters involving Native people, you're engaging a colonial power. And so whether you're in federal court arguing reparations or anything else, it's a colonial power. Keep going. And so you got to decolonize your mind, which means learn your language, start using your language. We're going to start submitting documents to the federal government in Lakota and let them translate it, right? Because we understand it. They always had it in English and expected us to understand it. And of course, it was fraudulent in large part, all right? So decolonize your mind, right? You take over the discussion. When they say government to government, you come back, you say nation to nation. It's not government to government anymore. Even Biden recognized that in his executive order. It's nation to nation, right? When they say doctrine of discovery, you say doctrine of theft. You know, when they say the doctrine of trust responsibility, you say doctrine of domination. You know, so you take it over, you take over the discussion, and you frame it within your context. It's called critical legal thinking, and there's a whole line of studies on that. They call it tribal crit. Next slide. And so reparations for human rights violations. This is also important for the Native people here that are involved with the descendants of the African diaspora, right? Reparations isn't just money, you know, and a lot of it's, well, we're going to give you so much money because you were slaves, right? That's not what it's about. You lost your identity. You lost your culture. You lost your people. You've been separated from your homelands, right? You lost your family. And so reparations involve a lot more. Next slide. And there's a document on this that I encourage everyone to read. It's a UN document adopted by the General Assembly. It's basic principles and guidelines on the right to remedy and reparations for violations of, gross violations of international human rights and humanitarian law, right? And this is a cookbook. It sets out all of what all your reparations, your restorative justice rights are. This is where they get the Truth and Reconciliation Commissions. This is where they get the right to truth. This is where they get where you correct your history books. This is where you get the right to have radio and television tell your story. And this is where you get where the people that have violated your rights have to pay for it, right? And it's all laid out in this one guidelines. Very few people pay much attention to it. There's a book on indigenous reparations by Federico Lenzerini. He spends a lot of time on this. It's a big volume, big book, main book. He's an Italian professor. I think he's teaching indigenous law at the University of Miami right now. Next slide. So we're involved in the land back movement, which is part of reparations. Next slide, and so forth. One thing I wanted to mention, I mentioned Vattel before in the Law of Nations. He said that people who do not submit, who do not voluntarily submit to the rule or the invasion or domination of another power are still engaged in a state of war. A state of war subsists. So it's a perpetual war until colonialism ends, right? Doesn't mean you have to take up weapons, but the resistance is an act of war. Remember lawfare. Next slide. And that's a rule of law he's stating, all right? So these are attorney warriors against colonial rule that some of us recognize. Mahatma Gandhi, what was he all about? He was a lawyer opposing the rule of the British in India. We have Pedro Bizu, right? Yeah, right. He was a lawyer. He went to Harvard, right? And then you have Mandela. He was a lawyer, and he fought for the rights of people in India before he came back to South Africa and fought there too. All right, and so you can be a legal warrior as well. Next slide. All right. So we call in Lakota, we call warriors Akitsita. And these are some of the warriors there. Yeah, I always like that poster there where they talk about Homeland Security, who's actually providing it and so forth. But that's what Standing Rock was all about in those. Next slide. So Mitaku Yoasin, that means all my relations. It recognizes that we're all related in some way or another. Next slide. And Wopala, which means thank you. Thank you.
Thank you, Andy. And that was worth going over time, but we are over time. So we're going to stop here, let folks